Good evening, Bios Baptist Church in Georgia studies. Today we will be learning about the structure of our court system. So, there are three types of courts.
I have a question. What are those three types of courts?
Yes. So, you have the appellate courts, the original jurisdiction courts, and the limited jurisdiction courts. So, what is the appellate jurisdiction courts? Georgia's Supreme Court is the state's highest court. It is an appellate court that reviews decisions made in civil and criminal cases by a trial court or by the Court of Appeals. The Supreme Court also is the only court in the state that can rule on certain type of cases. Two examples are cases about whether laws passed by the legislature are unconstitutional and cases involving challenges to elections held in the state. In addition, all criminal cases that result in a death sentence come before the Georgia Supreme Court. Decisions of the Supreme Court are binding. That is, they have the final authority on matters of law at the state level. Supreme Court also outlines a code of jurisdictional conduct for the judges of the state and regulates admissions of attorneys to practice law in the state of Georgia. The head of the Supreme Court is the Chief Justice. There are 7 justices on the Georgia Supreme Court. They are elected to 6-year terms in statewide, nonpartisan, not associated with any political party, that is a nonpartisan, elections. The Court of Appeals is the second highest ranking court in the state. It too has appellate jurisdiction. It is a court of first review for many civil and criminal cases heard by trial courts. This review is intended to correct the legal errors made at trial error. The Court of Appeal has 12 judges who are assigned to one of the 4 panels made up of 3 judges each. 3-judge panel review the transcript or the written record of the trial and the briefs, written arguments, submitted by the attorney for the parties. Judges hear oral arguments in a small number of cases, and judges are elected to 6-year terms statewide, non-partisan elections. So, any questions? What is an appellate jurisdiction? What level is an appellate jurisdiction?
The highest level.
Which is?
It's the highest level of jurisdiction.
In the
state. State level.
So, the appellate jurisdiction is the state level. Let's go down. Going down. Original jurisdiction. Superior courts. 49 circuits. Going down. Oh, wait, let me get off here. Let's see. Okay. In Georgia, the centerpiece of the original jurisdiction is the trial courts. It is known as the Superior Court. The Superior Court hears both civil and criminal cases, and Superior Court judges preside over all felony trials. This court has exclusive jurisdiction over cases of divorce and land titles, ownership disputes. It also may be corrections, errors made by some limited jurisdiction courts. There are 49 Superior Court circuits, or regions, with 207 judges. Some of these circuits consist of more than one county. Each judicial circuit has a chief superior court judge and a number of other judges authorized by the General Assembly. Superior Court judges are elected to 4-year terms in circuit-wide nonpartisan elections. A candidate for Superior Court judge must be a lawyer who has practiced law for at least 7 years. So, take us going down. Limited jurisdiction, state court, juvenile court, probate court, magistrate court, ground floor, learning time. Courts of limited jurisdiction. State courts exercise limited jurisdiction within one county. So, what county are we in, Roderick Earl Durden II? Yes. So, how many courts are here? How many counties are in the state of Georgia?
159.
Yes. So, how many juvenile courts?
159.
Probate courts?
159.
Magistrate courts?
59.
State courts?
159.
Go!
Oh, my bad. I meant 70.
Yes! So, that's the limited jurisdiction. Magistrate courts are limited jurisdiction county courts that issue warrants, hear minor criminal offenses, hear civil cases amongst amounts of $15,000 or less. Probate courts are courts with limited jurisdiction. When somebody dies, they hear submit the deceased person's will for probate. Probate is the process of establishing the validity or legality of the will. Dealing with the wills and estate of property and deceased persons is the role of the probate court of each county. They also issue marriage license and licenses to carry firearms, and appoint a legal guardian or order for involuntary hospitalization of an incapacitated adult or someone with dementia, for example. So, they most likely deal with, what do they deal with, Earl? Earl?
Social law.
Yes. Why do I keep showing you this boy's eyeball? Let's go. Juvenile courts were established to concentrate attention on the treatment of juveniles. Limited jurisdiction juvenile court handle all cases involving deprived or neglected children under 18. Delinquent or unruly offenses committed by children under age 17 and traffic violation committed by juveniles. These courts have also heard cases involving minors petition to marry or enlist in the military, procedures for the return of a runaway child who has been taken into custody in another state. So, Roderick, if you run away to Louisiana and you get taken in custody there, the state has to petition for your return. Women were not allowed to practice law in Georgia courts until 1915. Wow. The first women and the first African American were appointed to the Georgia Court of Appeals in 1984. So, can you imagine African American women? Now, it was harder for them. So, what is a jurisdiction? What is a jurisdiction?
The authority for a judge to hear a case.
Not necessarily a judge. Where is the judge working?
Court.
Yes. What is a jury?
I know this. I think it's a group of people who come to a decision on a case.
Talk louder.
I think it's a group of people who come together and decide on a case. That's what I think a jury is.
Yes. What is an appeal?
Appeal. I've heard that word before. But I've never understood exactly what it was. Oh, now I remember. An appeal is to take a case to a higher court for a hearing.
For rehearing, yes.
For a rehearing.
What are Georgia's two appellate courts?
Isn't it the Supreme Court and the Court of Appeals?
Yes. And finally, why do you think judges are elected in nonpartisan elections? So why can't judges have a political party? You hold the camera and record yourself.
Is it recorded?
Yes, properly. Hold it.
Okay.
Just wait. Yeah, just like that. So tell them. Why do you think?
I've never understood why, to be honest with you.
So let's have a discussion. So keep the camera on you. So when you're nonpartisan, that means you are not with a political party. So one political party may agree with something that the other one doesn't.
And then that becomes a big debate, and so that's why I think a judge isn't a part of a political party, because let's say you send a Republican to jail. The Democrats might not like that and be like, oh, I think he should have got this, or he should have gotten that. And so that's why I think the judge is like, you know what? I'm not going to be, I can't be a part of a political party, because what if I do something, that upsets either one of them, and we don't want to start a big fight or anything like that. So that's why I think a judge shouldn't be, or isn't partisan.
But here's the rest of the discussion, though. So the reason why I think that they should be tied to a political party. I think they shouldn't be tied to it mainly because, judges, they hold the responsibility to uphold the law equally. So therefore, when you are tied to a political party, you will uphold like say a Republican would uphold his side of the law, while Democrats won't. So national security and militarism is a big deal for Republican and conservatives, but it's not for Democrats. So if any event where a Democratic person
I gotta take that, hold on.
would rule over a situation such as let's say a matter of national security, they would not want to take the ruling properly due to the fact that they actually, they won't want to rule on that side because they don't believe it, and then that causes corruption inside of our great court system.